Good morning everyone, I'm Muhammad Rashdan and welcome to today's Business Law News. Today, we will be presenting case study 1, the catering that never was. This case involves a contract dispute between Selera Maiwar Catering Sdn Bhd and Prestige Convention Hall Sdn Bhd. Let's begin by introducing the parties involved. Selera Maiwar Catering Sdn Bhd is a halal certified catering company based in Shah Alam. Established in 2015, the company provides premium catering service for corporate event, gala dinners, and banquets. The second party is Prestige Convention Hall Sdn Bhd, a convention hall in Petaling Jaya. The company organizes corporate event but does not have its own catering kitchen, so it hires external catering companies. In September 2025, Prestige Hall was hired to organize a year-end appreciation gala dinner for 350 guests. The contract Selera Maiwar Catering to provide a 5-guest halal dinner. After discussing the event requirements, Selera Maiwar sent a quotation for 78,000 ringgit. On 1 October 2025, Prestige Hall officially accepted the quotation and later paid a 50% deposit of 39,000 ringgit. After receiving the deposit, Selera Maiwar began preparing for the event. The company ordered imported Wagyu beef, hired additional staff, and purchased special equipment, spending about 27,500 ringgit on preparation. However, on 18 November 2025, less than 4 weeks before the event, Prestige Hall suddenly informed Selera Maiwar that the gala dinner had been cancelled because its corporate client was facing a regulatory audit. Selera Maiwar then requested compensation for its losses, but Prestige Hall refused. Instead, Prestige Hall demanded the return of the 39,000 ringgit deposit and argued that the cancellation was beyond its control. The company also later questioned the halal certification status of Selera Maiwar Wagyu beef supplier. This concludes the introduction and background of case study 1. Thank you.
Good morning everyone, I'm Shazri and I will be explaining the contract law as a legal analysis. Based on the fact of the case, there is a strong agreement that a valid contract was formed because the expectation element of the contract were present. On 25 September 2025, Selera Maiwar sent a formal invitation to Prestige Hall. The questionnaire clearly stated the catering service but because a dinner minimum number of the guests, total contract price of 718,000 Malaysia ringgit payment term and other service detail. Since all the important terms were clear that the quotation can be considered a valid offer under contract law. On 1 October 2025, Prestige Hall sent an email to Selera Maiwar stating, "We confirm acceptance of your quotation that 25 September 2025. The email also stated that the company will process the deposit payment. They show the Prestige Hall agree to the offer and intend the payment with the contract. In addition, Selera Maiwar received the 39,000 ringgit deposit on 3 October 2025. After receiving the payment, the company immediately started preparing for the event. They ordered imported Australia Wagyu beef, additional staff booking, receiving staff, and purchase customs dessert display equipment. As action clear, so the both party we are forming the contractual obligation. However, there is one important legal issue involving the purchase order. Although Prestige Hall aspect the quotation, the purchase order attached to the email include the additional clause. The clause that in the menu 10% from the agreed specification. Prestige Hall at the menu impose the 50% penalty on the total contract value. Selera Maiwar did not sign or formally reply to this application clause. However, Encik Rastam admitted that he agreed to purchase order and did not raise any objection. Instead, Selera Mewah expect the deposit and include preparing for the event, because a court may need to decide whether additional clause because part of the contract of the condition of the party or whether only the original precision should apply. In conclusion, there is a strong agreement that a valid contract is because there was a clear offer and clear expectance payment of the deposit, and both parties act according to the agreement.
Good morning everyone, my name is Riglendi and I will explain to legal issue in this case. First the convention hall cancelled the gala dinner after this corporate clean was affected by a regular audit by the Security Commission. As a result, the event was cancelled. Before the cancellation, Selera Mewah Catering had already received 39,000 ringgit deposit and spent about 27 and 500 ringgit and preparation including important Wagyu beef, extra staff and transportation. Prestige Hall agreed that the contract was discharged due to frustration under Section 57 of the Contract Act 1950 because the audit was beyond its control. However, Selera Mewah agreed that the audit did not make the catering service impossible. Therefore, it made be considered a beef of contract and Selera Mewah is claiming compensation. The second issue is a presentation regarding halal certificate. During the negotiation, Selera Mewah stated that the imported Wagyu beef come from Jakim supplier. However, Prestige Hall later found that the supplier Jakim recognition had expired. Selera Mewah explained it did not know because the supplier website still show the old certificate. This may consider innocent misrepresentation because the false statement was made without the intention to deceive. The court will decide whether this affected the contract and what legal reminders shall be given. Thank you.
Good evening everyone, I'm Eric and my part is application of law for this case. A valid contract existed between Selera Mewah and Prestige Hall. Selera Mewah made an offer by sending the quotation and Prestige Hall accepted it by email and paid a RM 39,000 deposit. Since there was an offer, acceptance, consideration and intention to create legal relation, the contract is legally binding under the Contracts Act 1950. Next, Prestige Hall is likely to have breached the contract. They cancelled the event less than 1 month before the agreed date, after Selera Mewah had already purchased imported Wagyu beef, hired additional staff and spent around RM 27,500,000 preparing for the event. Even though Prestige Hall's client cancelled the gala dinner, that doesn't automatically remove Prestige Hall's responsibility because the contract was between Prestige Hall and Selera Mewah. Prestige Hall also argued that the contract was frustrated because its client cancelled due to a regulatory audit. However, the doctrine of frustration is unlikely to apply. Frustration only applies when contract becomes impossible or illegal to perform. In this case, the catering service could still have been provided. The cancellation happened because of the client's decision, so it is considered a commercial risk rather than legal frustration. Another issue is the additional clause in the purchase order. Prestige Hall added a new penalty clause after accepting Selera Mewah's quotation. Since Selera Mewah never clearly agreed to this new term, it is unlikely to be legally enforceable. Finally, Prestige Hall claimed that Selera Mewah mispresented the halal certification of Wagyu supplier. However, there is no evidence that Selera Mewah intentionally gave false information. Encik Rasdan believed the supplier's certification was still valid and the event was cancelled before any food was served. Selera Mewah is more likely to succeed in this case. Prestige Hall is likely liable for breach of contract because there was a valid agreement. The cancellation was not legally justified and the defense of prestation is unlikely to succeed. Therefore, Selera Mewah may be entitled to recover its preparation costs, reasonable loss of profit, and possibly retain the RM39,000 deposit. Thank you.
Good morning everyone, my name is Wong Chiu and today I will be taking the part of mistakes made and how the problem could have been avoided. Firstly, Selera Mewah Catering has made the mistakes of not carefully reviewing the purchase order before accepting it. The purchase order contained an additional penalty clause that was not included in the original quotations. Although when Chirashna noticed the clause, he assumed it was a standard term and did not raise any objections. In contract law, parties are generally expected to read and understand the terms before accepting them. Secondly, Selera Mewah also represented that the imported Wagyu beef supplier had valid Jakim halal recognition. However, it was later discovered that the supplier's recognition has already expired. Even though Encik Rashdan claimed he was unaware about this, businesses have a responsibility to verify important information before making representation to clients. On the other hand, Prestige Hall also made several mistakes. They cancelled the contract only a few weeks before the event without discussing compensation for the losses already incurred by Selera Mewah. They also rely on the cancellations by their own client as a reason to avoid liability, even though the catering contract was a separate agreement between Prestige Hall and Selera Mewah. To avoid similar disputes in the future, both parties should carefully negotiate and confirm all contract terms in writing and before signing. Businesses should also verify important certifications, maintain clear communication throughout the project, and include detailed cancellations, and force major clauses that clearly explain each party's rights and responsibilities. So in conclusion, the case highlights the importance of proper contract management in business transactions. These disputes arose because of unclear contract terms, last-minute cancellations, and concerns about the halal certification of an important ingredient. These issues demonstrate why businesses must carefully review contractual documents, communicate openly, and verify all important information before entering into an agreement. Overall, this case shows that understanding business law is essential in protecting the rights and obligations of both parties and reducing the risk of costly legal disputes. Thank you for listening, and that's all from us. Thank you.